Hello everyone, welcome to part 3 of our discussion of competition law. In previous videos, we've looked at the key concepts underpinning consumer law and the prohibitions against cartel conduct. In this video, we'll look at some of the other arrangements that can affect competition. These include prohibitions against lessening competition, boycotts, misuse of market power, exclusive dealing and resale price maintenance, and acquisitions that substantially lessen competition. First, let's look at prohibitions on lessening competition. In some cases, this will look a lot like cartel conduct, as in essence cartel conduct does involve making a contract, arrangement or understanding that lessens competition. However, the difference is that the prohibitions under section 45 are broader and can cover a range of other conduct that lessens competition without being cartel conduct like price fixing. For example, in the flight centre cases, travel agents attempted to dissuade airlines from advertising airfares that are cheaper than what Flight Centre was offering. This wasn't price fixing, as there wasn't a restriction on supply of services, but nevertheless it reduced competition to the detriment of consumers. Boycotts are another form of anti-competitive behaviour. You'll probably be familiar with the basic premise of a boycott, which is where a group of parties refuse to deal with a particular business. Commonly, this is done as a protest, which we'll talk about in a minute. But from a competition perspective, what we're most concerned about is where a boycott is used to harm a competitor. Consider a scenario where two companies are the only suppliers of rare clocks to two antique shops, A and B. Shop A approaches the clockmakers with a tempting offer. They're willing to pay a higher price per unit if the clockmakers agree to stop supplying their clocks to B. Cut off from the market, B has to close down, thereby leaving A with no competitors in the market of selling rare antique clocks. They have a monopoly and they can charge whatever extreme price they want. This is the kind of situation that the boycott provisions in section 45 is trying to prevent. There are two kinds of boycott: primary and secondary. Primary boycotts arise when two or more competitors directly boycott a target. In the earlier scenario, the clockmakers boycotting shop B. A secondary boycott occurs where two or more parties indirectly boycott a target by boycotting a fourth party. To look at how this works, let's consider another example. A and B are manufacturers of a kind of product. Let's say they brew premium beers. They each sell their beer to D, who then in turn supplies it to C, a retailer who sells the beer to consumers. A and B want to boycott C, perhaps because C hasn't been selling their beer at the recommended premium price point. They can't directly stop C from doing that, but they agree to stop selling the beer to D, in turn cutting C off from their supply. This reduces competition because it sends a signal to other retailers that if they don't follow A and B's pricing structures, they too will be cut off. There are two exceptions in relation to boycotts: boycotts from employment matters and boycotts for environmental or consumer protection. The former might arise, for instance, where a company refuses to deal with other companies that underpay or exploit their workers, or which do not meet occupational health and safety standards. Environmental or consumer boycotts are more common, and might include, for instance, refusing to deal with companies in the protest of their unsustainable business practices. A good example is boycotting palm oil products to preserve orangutan habitats, or boycotting companies that are notorious for breaching consumer protections. Corporations that have a substantial degree of power in the market are prevented from misusing that power. As always, working out what the market is will be a critical first step, following the factors that we discussed in the first video. From there, we need to determine how much power the corporation has within the market. This is itself a difficult task and will be determined with reference to competitors as well as the corporation itself. Nevertheless, in some cases it will be pretty clear-cut. In the groceries sector, Coles and Woolworths clearly have a substantial degree of power, and Bunnings completely dominates home hardware. If it's established that a corporation has a substantial degree of power, they are prevented from misusing that power. In other words, they can't eliminate or substantially damage a competitor, they can't prevent new entrants to the market, and they can't attempt to deter or prevent a person from engaging in competitive conduct within the market. In practice, it can be quite difficult to establish that a misuse has occurred. For instance, Section 46 won't stop Coles from opening a great big store across the road from the local independently owned grocer, even though Coles' ability to set low prices will most likely harm the local grocer's ability to compete. The situation is really complex in scenarios like groceries where the industry is dominated by two powers, Coles and Woolworths. Price wars over milk and bread, for example, enhance competition between the two main companies but harm smaller enterprises who can't keep up. In that kind of scenario, this conduct will harm the smaller competitor, but we wouldn't say that it's anti-competitive as it enhances competition between Coles and Woolworths. Accordingly, bodies like the ACCC have a lot of trouble actually enforcing anything in this space. Exclusive dealing and resale price maintenance are two further forms of anti-competitive conduct, and both are fairly straightforward. Exclusive dealing occurs when restrictions are imposed on the reseller in the way that they deal with the product, on the customers who they can sell the product to, or on the places to which the reseller can sell. These are pretty clearly anti-competitive because they limit the reseller's ability to be efficient and progressive in their own practices. Resale price maintenance is similarly problematic because it sets a minimum price for the goods or imposes some other restriction on the reseller's ability to set their own price. The key thing here is that, like our discussion of price fixing, a recommended retail price is not a breach because it's only recommended. Even if resellers invariably apply that recommendation, they still have the right to deviate from that price and therefore be more competitive if they want to. Finally, mergers and acquisitions that substantially lessen competition are also prohibited. The ACCC has a framework for assessing mergers, and they are guided by Section 50, subsection 3, which includes a non-exhaustive list of factors to consider. I won't go into them in too much detail, but the upshot here is that we're interested in the effect that the merger will have on competition within the market. So this will include things like the nature of the market itself, the number and relative power of competitors in the market, the likelihood that the acquisition would affect prices or profit margins, etc. It's also important to be alert for creeping acquisitions, where a corporation gradually acquires competitors, any one acquisition of which doesn't offend Section 50, but over time upsets the balance of competition within the market. That concludes our discussion of competition law. As you'll have noticed, it's absolutely critical that you're able to identify the relevant market and assess the degree of competition within it. As always, this will be guided by the facts, and characterization is a real skill in this field, as developing a persuasive legal narrative could influence the way that the market is constructed and whether a particular behaviour is seen as anti-competitive or not. Practicing those skills is therefore very important for this area of law. See you next time.